In this video, I'm going to speak on three new textbook in chapter 4. These areas have to do with liability to the landowner or the project owner, to the architect, engineer, any other consultants on site, and as well as general contractor and subconsultants for that matter. The first is a breach of contract. This is the general tort that is used in most construction claims. The next is negligence, and that's where non-monetary damages are sought for injury. And the third is going to be the statute of limitations or statute of repose for the state of Maryland. Each one of these topics I will be giving you relate to the laws of Maryland, and hopefully they'll be helpful to you and certainly open your eyes, and they should be in addition to things that are in the book. In a breach of contract situation in the state of Maryland, everything is governed by case law, or in some cases actually a statute. And the running statute is a discovery rule. So basically, the statute kicks in from when something is discovered, or when a reasonable person should have discovered the problem. And so under that, there's a general 3-year rule on the statute of limitations. So basically, if there's a breach in the contract and you should have discovered it, that 3-year window is ticking. And if it's something that a reasonable person wouldn't have found until it happened, then the 3-year window starts when it happens. There's an exception to this 3-year rule, and that is called a limitations for contracts which are made under seal. And that's where you see the word sealed next to someone's signature. And as a lawyer, I try not to get people to do that. That's what I would say. You don't want them to be held liable longer than they need to, but sometimes that might be required by somebody to actually seal a contract. So that's generally the issue with regards to a breach of contract. Breach of contract is usually performance related or monetary related. Oftentimes you might, if it's a construction damage, you have to repair it. You might get replacement value for what was like a fair market value of the repair compared to what the cost was paid for the defect. There's most of the time, like I said, most of the time the incidents involved center around a breach of contract. So whatever the type of issue there is, you start to look at the contract. Who was responsible for what under a contract? And if we're talking monetary damages, cost to repair things, if we're talking delays in construction, a lot of other damages similar to that, we're talking breach of contract. And some of these other damages I'll speak about in later modules, but this is primarily the biggest area is a breach of contract. The next area is that of negligence. Negligence is literally is what it sounds. It's negligence, where somebody was negligent and somebody else is harmed. But there's more to it with regards to contract law and the construction industry than just saying somebody was negligent. Negligence, there's actually 4 components or 4 elements to a negligence claim. It is a tort claim. So under negligence, you need 1, a proof of some duty. A person has to have a duty to the injured person. They have to then have breached that duty, and that breach has to be the proximate cause or the thing that caused the injury. And 4, there must be actual damages. In Maryland, negligence claims are they're limited by what's known as the economic loss rule, which generally holds that the person filing the complaint, the plaintiff, cannot recover in a tort for purely economic losses. So if all you're claiming is a loss of money, you don't have a negligence claim. Loss of injury to somebody, severe injury to a person, those are negligence claims. Otherwise, you're generally dealing with a breach of contract claim. Maryland has something that I want to think that when I took the bar exam, only 2 or 3 states actually have something that Maryland has, and that is called contributory negligence. Maryland is a state where if somebody participates in the negligence, then they're going to reduce the liability of the person who caused the problem. So let's just say it's a construction issue, it's mold related, you've got some leaking water, some coming through someplace, or maybe some weak ventilation or something where you're not getting all the humidity out with an HVAC system, and you start to develop mold in an apartment building or some office building, and the tenant or owner, they don't recognize, or they don't do anything about it. They recognize it, starting to get moldy. They don't do anything about it. A lot of time goes by. Now the mold problem is really bad and begins to cause a health issue. Well, that would be contributory negligence. And so while maybe there is some negligent act with somebody who designed or installed the HVAC system, that damage is being offset by the owner's actions. That is contributory negligence. And it is one of the very rare things that Maryland has where few states do. And like I said, it was something that was tested on the bar exam. And most states have comparative negligence, but contributory negligence is a much different situation where you can actually, if the owner is at fault to a certain extent, they can actually eliminate the liability on the person who caused the action in the first place. So it's a much different situation than other states with comparative negligence. Another area of negligence is the duty that an owner of land has to those that enter in upon the land. This is a non-delegable duty to anybody that comes on the land. In other words, the owner has certain duties that they must adhere to regarding anybody that enters onto their land, whether it's your house or whether it's a construction site. And you cannot hand those duties off to somebody else. A big case in Maryland was actually involved Whiting Turner, which was one of the companies in the videos this week, Turner. And it basically says that the owners cannot delegate that duty, and you cannot pass it on to someone else. So, when somebody enters into your land, whether they're an agent of somebody else or a subcontractor, you have a duty to make sure that things are safe. So while the owner might pass some of that off onto a general contractor who's building it, it's still ultimately an owner's responsibility to make sure that conditions are safe, that, not working conditions so much, but open and obvious and dangerous situations. Like, you can't have a giant hole left in the middle of the ground, even if somebody's going to come back and work on it the next day. If for instance, anybody can enter into that property and fall in a giant hole and die, that's something that is obvious and should be fixed and remedied, and it can fall back on the owner, even though it might have been done by a contractor for some reason. In project management, there's another area that you should be aware of. In general, employers or contractors are not responsible for the actions of an independent contractor or subcontractor. However, if your hiring of that independent contractor or subcontractor was a negligent hiring, then you can also be held liable for their actions. A typical example of this might be, if you have a subcontractor that is a delivery person, you're going to be the person who's your gopher, They're going to deliver permits, they're going to deliver bonds, they're going to deliver plans, they're doing all sorts of errands for you like that. And you don't check their driving record, and you find out that their driver's license is suspended because they had 3 DWIs, and they're drunk behind the wheel carrying your plans to the county building for some reason, you're probably going to be held liable for them, even though they were an independent contractor, and otherwise you wouldn't be. It was a negligent hiring. So you have to be careful with your hirings, because even there, you think you're passing negligence on to a subcontractor and you're not responsible for their actions, you could possibly still be responsible. The final area is that of the statute of repose. I'm going to actually read to you the statute of repose. It is found under the Courts and Judicial Proceedings article of the Maryland Code in section 5-108. And the relevant portion of it is found in subsections A and B, where it says that except as provided by this section, no cause of action for damages accrues, and a person may not seek contribution or indemnity for damages incurred when wrongful death, personal injury, or injury to real or personal property from the defective and unsafe condition of an improvement to real property occurs more than 20 years after of the entire improvement first becomes available for its intended use. Except as provided by this section, a cause of action for damages does not accrue, and a person may not or indemnity, this is important, from an architect, professional engineer, or contractor. Have also been added to that in a different location, for damages incurred when wrongful death, personal injury, or injury to real or personal property resulting from unsafe condition of an improvement to real property occurs more than 10 years after the date the entire improvement first became available. And once you find that accrual of, you have 3 years to file a claim. So architects, engineers, surveyors, general contractors as well, anything that's regarding a personal injury claim or any significant injury for real property, which is the land and the building that sits on it, or personal property is any other type of property basically that you can see and touch. I mean, you know, your clothing, your anything that's inside the contents of a building, that's personal property. They're not held responsible for more than 10 years. So as a surveyor, an engineering company, we records for a minimum of 13 years, and that's what the insurance company mandated as well. So you'd hold on to them for the 10-year period, and if anything popped up in that 10th year, you might need to hold on to things for 3 more years. So we would hold on to things for 13 to 15 years. You didn't want to be responsible for it. So in Maryland, the purpose of it was to protect builders and contractors and anybody else tied to the development and construction of anything that's on real property. At first it was 20 years, but lobbyists got involved, and 10 is much more reasonable in my mind. It's there, but basically as construction industry, we have 10 years for the liability on our products. Therefore, you're actually carrying insurance for 10. You build a building, and you're going to have to insure the design of that. You're going to have to insure the construction of it, and all these different for a period of 10 years after the date that it was built. So this week on breach of contract, negligence, and the statute of repose. If you have any questions, we'll talk about it in class. And again, I look class. Thank you.